us why are you seeking, or why have you sued the defendants, and what are you seeking?
Yes, thank you, Your Honor. So I am seeking the commissions that I was owed, in short, for my work as an independent contractor, commission sales closer. And I'm also seeking a refund. I was also a client of Ms. Tate's in the program, and I'm seeking a refund of what I paid in the program. And I'm also seeking legal fees that were related to the counterclaims that Ms. Cutler brought up during the filing of this case.
How much are you owed for commissions?
So for commissions, it's $11,062.72. And I also want to add, I had another role in her company as a coach. It was very short, but so I'm also asking for the $400 that I was owed for my work as a coach.
All right, and how about a refund of services?
$4,410, excuse me.
All right, and have you had any out-of-pocket legal fees other than your cost of filing in court?
Yes, I had, I received legal notice from Brian Levy in Treaty Oak Law Group, and I engaged with an attorney to respond, and it was a $1,500 retainer, of which the other than $158 has already been used of that $1,500, and the $1,500 is non-refundable.
Are you represented by counsel?
I'm not today.
What did they do?
So Treaty Oak Law Group sent me a legal notice. Yeah. And initially, this was obviously before we filed here. So initially I engaged with counsel to respond. So they responded to Treaty Oak Law Group regarding their allegations. And moving forward, I couldn't afford to go out of pocket for an entire court process. So I decided to move forward pro se.
So you incurred that expense prior to you filing your lawsuit?
Yes, Your Honor.
Okay, and that was, you said, about $1,400?
15.
But they still have 189 remaining?
153.
Okay, so.
But it's not, the 15 is non-refundable, but it's okay. I'm happy to. It's a non-refundable retainer.
Who'd you hire?
Deshino and Shami in Florida. And I have their invoice as well as the itemized. I live in Florida.
Oh, that explains it. Okay. All right. Okay. So commissions, coaching, refund, legal fees.
Correct.
When were you, you said that you were an independent contractor, you did sales work for the defendant, is that correct?
Correct.
When did your working relationship with the defendant first begin?
I was approached by Ms. Cutler sometime in August of 2025. And my first sales calls began at the beginning of September, I believe September 3rd or the 1st, if not.
When you met with her in August of 25, did you in writing confirm what the agreement was going to be for how you were going to be compensated?
There were text messages exchanged. And so we did confirm. Initially, it was a 10% commission paid as she collects. And then we had a few recorded calls where we continued to exchange the terms of my responsibilities and the steps and hers. And then there was also
a formal independent contractor agreement signed between you and the defendant. So is there anything formally illustrating when to be paid, what happens if things go wrong? Or is there anything other than a sort of casual text message creation of this? Okay, so we've got a very loosely based contract for work. It was going to be paid as the defendant collects. What if she never collected?
Correct. So part of my responsibilities was to set up the clients with their credit card payment and to set them on auto pay. And the reason why I agreed to a pay as collect is because Ms. Tate also had a responsibility to send the clients their own contract. In that contract, there was a non-refundability clause as well as a responsibility to pay for defaulted payments. And that gave me the confidence to accept a pay as collect term in my own engagement.
Y'all didn't actually discuss what happens if she doesn't pay, if she never gets paid.
Correct.
I mean, the answer is if she doesn't get paid, you never get paid.
Well, she does have that documentation
I know,
with the
but
clients. Yeah.
I deal with
Sure,
people
that
who
was an
promise to pay all
assumption.
the
Sure.
time. There's a reason courts exist, right? So the fact that she says I'll pay you when I get paid means if she never gets paid, you never get paid. No, that is the answer. If it is a conditional statement, it requires a condition to be completed. Okay, so your commissions are based upon her collecting the money. You're gonna get a 10% of that. Did you provide the bills to her so that you could calculate the 10%?
Correct. And I want to be clear at a certain point on September 30th, prior to the month completing, we had a recorded video call where Ms. Tate changed my commission rate retroactively for that month to 17%.
So for the
because
month
of my performance.
Of August or September?
September, which is when my calls began.
Okay, so it was gonna be 10% when she recruited you, but then you actually had a great first month, and so she said retroactively, I'll pay you 17%.
Correct, based on a sales threshold that I met.
Was that something y'all had discussed in August?
No, what we had discussed in August was certain payment expectations. I brought up to Ms. Cutler that what I was receiving fell short, even though I was performing beyond the expectations. And so that was her way of fixing that.
Were you not getting 10%?
Well, I hadn't been paid yet, but I was doing the math and she had given me numbers of what I can expect based on the price of her course and based on certain close rates. And I was showing up to the calls, getting those close rates, and the math was off. I think it was just.
Okay, here's another question, Ms. Ramos, because this is going to go into what Mr. Levy's answer is. Who did you have your communications with in these text messages? Were you talking to Ms. Cutter or were you talking to Unfuckable? Or I'm sorry, Unfuckwithable. Let me be clear about the name of the defendant.
I was speaking, I mean, it was a text message with Ms. Cutler.
This is an important part of the case, Ms. Ramos, because Mr. Levy says that you're seeing her incorrectly. So you got to tell me, were you talking to her as a individual, Ms. Cutler, or were you talking to her, Ms. Cutler, owner of an LLC that was hiring you to do sales work?
I felt like I was speaking to an individual because Ms. Cutler is the face of her business. She's the sole owner.
But it was the face of a business.
Mm-hmm.
So you weren't talking to just a woman named Ms. Cutler. You were talking to Ms. Cutler who owns a business.
Sure. To be clear, my filing, because Ms. Cutler resides in Texas, my filing was in Texas because when I first searched her Tate US LLC, it didn't show up on the Texas Secretary records. So my filing was her individually solely because I couldn't figure out where her business was located. It wasn't until February that she actually filed with with the Secretary in Texas, like put her business, which is apparently in Delaware, was then filed to be able to do business in Texas. It's not, I don't know if what I said was clear.
Yeah, no, that's actually very common. So now my question then is, Ms. Ramos, it sounds like you sued her as an individual because you didn't know how to find her company. Now that you know how to find her company, are you wanting to still pursue her as an individual, or were all of your interactions with her is her role as owner of an LLC?
Your Honor, I don't have a preference as to whom the filing is for. If it makes sense for her to file the company or for her individually, I'm okay. I just want what's owed to me.
Ms. Ramos, that is a legal question that I cannot answer for you. It is a distinction in who you're pursuing, and
I put both. So all
right. That's good information. All right. All right. So you did have interactions with Ms. Cutler. You knew that she had this LLC. Originally, when she recruited you or when y'all were discussing it, you were going to start getting paid commissions at 10%. And did you also sign up for a class at that time?
No, I was a client of hers prior to that time.
So you knew her before this communication in August?
Correct. So I was initially a client of hers, and April 16th was my official start date.
When you say you're a client, what classes were you taking?
So Ms. Cutler had a program that included group coaching as well as access to a platform and a community. And so I would show up to the group calls and watch the recordings and communicate with the members of the community for how to build an online digital business.
And you began that in April?
Correct.
All right. How much did you pay? Was it a one-time flat fee, monthly?
I paid a total of $44.10, and that was split over 4 payments.
But what'd you sign up for?
$44.10.
So it was a package. It was all one flat price.
Correct. Yes, correct, Your Honor.
All right. And was there a specific set of information, like you're going to get these things as a result of paying $44.10?
Not in writing. I never received an actual like a client agreement. It was all through a video with one of her closers at the time. But yes, it was access to the program. Yeah, the access to the group calls and the program and the community.
How did you pay the $44.10?
With a credit card.
Okay, and did you get receipts for those?
I did, and they're part of the exhibits.
Did you get any kind of agreement in writing or a contract that says here's what you're getting for $44.10?
No.
Anything at all?
Just the access to the platforms.
What's the platform?
It's a website called School, and Ms. Tate had her program on that website, and I was invited into that program, and also links to Zoom calls where Ms. Tate hosted group calls. And then part of that was also community and being able to engage with the other women in the platform and the community that had similar aspirations and wins and struggles and things like that.
All right.
That we could all.
You signed up for a class in April of 2025. You paid $44.10 for that. You participated in the class, and in August, a few months later, the defendant approached you about working for her, and you agreed. And you said, I will do that, and you'll get 10% when she gets paid. You did a month of work. Your work was better than expected, but you were not making the money you thought you'd get for what you heard from a class. So the defendant—
No, from what I heard from Ms. Tate, excuse me, I don't mean to interrupt you, Your Honor. From what Ms. Tate said in her original offer.
Oh, what she pitched you would be able to earn, you weren't really earning it that much, which is, not uncommon. People say that all the time.
Sure.
But she said, all right, well, I'll pay you 17% instead for the month of September.
Correct.
And as a result of that 17%, what were you supposed to be paid in September?
So it was as collected, and I have an exhibit that shows each month. So that shows all of the clients, the calls, what I collected for each month, and then the payment plans that I would put them on. So some clients paid in full, some would pay a deposit, and then there would be payments over the next 4 to 6 months, some 12 months. And so I have a spreadsheet of what those numbers should be and what the 17% commission should be from that.
Have you received any payment from the defendant for work you performed?
Yes, I received a payment for 17% on October 2nd, and that would be Exhibit A4, which I also submitted.
How much money has the defendant paid you so far?
$4,139.50.
All right, and what do you claim she still owes you? That's the $11,062?
Plus the 400, yeah.
Plus 400 for coaching and then the refund. All right. Have you provided an itemized list of the breakdown for where the $11,062 comes from?
Yes, Your Honor.
Mr. Levy, is there any portion of the unpaid commissions that defendant agrees is owed?
Yes, Your Honor. If
I think he may be frozen. Everyone just froze. Mr. Levy, I'm sorry, I asked a question and it looks like everyone froze on my end.
Oh, can you hear me, Your Honor?
Now it's my Zoom that's behaving badly. Hello again. It tells me that my internet connection is being unstable.
Uh-oh.
All right, Mr. Levy, I had asked a question. Ms. Ramos says that the defendant had paid her $41,39.50 and that she has an outstanding balance of commissions owed of $11,062. So my question, just real quick, Mr. Levy, was, is there any portion of outstanding commissions that the defendant agrees is owed to the plaintiff?
Yes, Your Honor, and that is in exhibit number 4, defendant's exhibit number 4. It shows
how much is that?
That is $1,878.89.
So that's a substantial difference. All right, so how about $400 for coaching? Does defendant agree they would refund that or that they owe that to the plaintiff?
No, Your Honor.
Okay, how about any of the refund she's seeking from the classes she enrolled in? Any portion of that the defendant says they would refund or acknowledges should be returned?
No, Your Honor. And we provided her withdrawal from the class, and prior to that, she received all materials.
We'll go through it. I'm just straight up front. If there's any part of that that's conceded by the defendant, then I can go ahead and just sort of set that one aside and we can get into the rest of it. So
Absolutely.
1878 is acknowledged between the parties. That part is there. It's the remainder of the commissions that are at dispute and then all the other things. All right.
Yes.
All right. All right. So now, Ms. Ramos, you signed up for the class and you said that you watched a video in the class. The video gave you information about what you were paying for in the package. Did there come a point where you asked for a refund for the package that you had paid for classes?
Your Honor, the refund for the package is connected to legal notices that Ms. Cutler sent me. So there's a bit of a chronology where Ms. Tate, we had a disagreement about the recordings, which will come into, I believe, in their counterclaims. I was terminated from my closure role mid-sales call and mid-month in October. And I received 3 legal notices, 2 cease and desist from Ms. Tate personally and 1 directly to my home. And then 1 from Treaty Oak Law Group, Mr. Levy. And part of those cease and desist, I was demanded to cease communications with clients. And there was a bit of a murky area there because those clients were also part of the community that I paid to be a part of and to communicate with. And so that's where the refund comes in because I, part of that package was being able to communicate. And so if I can't communicate with what I paid for to be able to communicate, then it puts me in a bit of a legal bind.
Mr. Levy, are there any written terms and conditions for any of this stuff?
No, Your Honor. No, Your Honor.
No, I heard you. I'm just sort of taking that in. So we have $11,000 in commissions that are owed, but no one bothered to put any terms and conditions in writing. She's selling a package
Your
for a
Honor.
class, and there's nothing in writing from the law from LLC that says this is what we're going to provide when people pay us.
No, Your Honor. And not at the time.
Well, that's what matters, right? Coming up with postmortem isn't going to do them any good. It's at the time they entered into the agreement. So there's a whole lot of questions of fact because literally no one bothered to put anything down. All right, so we got no written agreements at all. Ms. Ramos, you said that in October, defendant said you couldn't do the work anymore. Sent you a cease and desist letter, told you weren't allowed to contact people or clients, but some of those clients were part of the referral network or the online community network that you were paying to be a part of. And so that's why you're wanting a refund because you couldn't do it anymore. Okay.
Correct.
Now let me ask you this. So you paid for a package and you did get to access it. And then in October, they stopped it. So why would you want the entire money back and not some pro rata refund?
Sure. So based on Texas law that was established, the Texas Prevention Doctrine, a party who prevents or makes impossible, sorry, I'm the wrong one, excuse me. Not a lawyer. But Ennis versus Interstate, which is when a party commits a material breach that goes to the entire essence of the contract, the non-breaching party has the right to rescind the contract and seek restitution of any money paid. And so this being able to communicate with clients was an essential element. And it was actually a really meaningful element that I still had access, that I was still supposed to have access to until April 2026. And when that was taken away, and because she initially took me off the platform, and then I wasn't able to communicate with the clients. I let her know I was back in, but then she sent me these notices. Thank you.
What's the reason the defendant told you to stop doing work in October?
So we had a disagreement about recording. So my sales calls were recorded for my own use. And I offered Ms. Tate to be able to review them if she wanted for some of them. And Ms. Tate on October 15th asked me for the actual downloads, like the actual files. And I didn't feel comfortable with that as the owner of the recordings and because of the content of the recordings. And because I did not give those recordings and I said that I wouldn't, Ms. Tate terminated me the very next day.
So you were doing work on her behalf and you recorded those calls, but you refused to give them to her?
Correct.
All right. And as a result, she terminated you.
Correct.
All right. All right. And then you said you received cease and desist letters from Mr. Levy's law firm or others with their firm? Is that the point of you hired of the lawyer in Florida?
Correct.
Okay. All right. So let's take a look at the breakdown for the commissions, the $11,000. Now, Ms. Ramos, I think you said you submitted that to the court in advance.
Yes. It will be Exhibit A3, Camila Closer Performance. This is also the majority of this, like the month-to-month breakdown was a file on Google Sheets that Ms. Tate always had access to. So she had a...
Ms. Ramos?
Yes, sorry.
Let me ask you a few questions. I need to establish this is useful for court. So I'm going to share my screen, and this is a 14-page spreadsheet. I'll just going to quickly
Correct.
See that most of it is all spreadsheet with some words at the end. Ms. Ramos, was this spreadsheet something that when did this spreadsheet get created?
At the start of my independent contractor role so that I can keep track of everything.
So this was originally opened in September of 2025.
Maybe late August I set it up, but sure. Yeah, I began filling it out with my calls. Yeah.
It was done in purposes of the job and not just for coming to court.
Correct. And
now,
it was a live document. Yes.
Ms. Ramos, would you, and how often do you update the spreadsheet?
Every day. I mean, every day I had a call and I would close it or not.
And was the idea of keeping a spreadsheet something that you decided to do, or were you instructed to do that by the defendant?
I decided to do it, Your Honor.
And then on this sheet, when I'm looking at it, I see up the top, I see some dates, I see calls, close rate, sales, average, commission, paid to date, all of these things. And then down here, how would you submit to the defendant proof that you had done work and needed to be paid?
Sure. So two things. One, this was a live Google sheet that the defendant was shared with and would update her in real time as I would update it. And then
so
at
the
the end of the
also had access to use the sheet?
To view it, not editor access.
Okay, go ahead. So she could see it.
And then also at the end of every call, when I would close a client, it was my responsibility to notify Ms. Cutler, the defendant, excuse me, and let them know the person, the amount of the total amount, and the email address so Ms. Cutler could send the client contract to the person that I had closed. And so that was part of our procedures. So I have a record of every text message, of course, that I sent with every closing, the name, the amounts, and the email addresses.
All right. Now you did work in September and you submitted that and asked for payment. And she did pay you at some point $4,139.50.
Correct.
And then in October, you're doing work. She sends you the cease and desist, or she tells you to stop because you weren't going to let her hear the videos that or the audio recordings. What is these numbers here going forward, November, December? Explain these for me.
So where it says collected amounts, that's the amount that that was, so the month of the transaction was, okay, sorry. The transaction month was what closed that day,
Or in October.
what was paid. Correct. And then each month also shows what the amounts were. So it's a little easier if you go to the next sheet. Would that be okay? So you see how this is each client and then what their total package was, and then what I collected on the day of closing, and then when their second and third payments would be, which were monthly. So the first sheet outlines those totals that would be, so I collected a certain amount in October, but some of that wouldn't be collected until November, December, January. So my first sheet is a summary of that. And then
you signed people up to pay packages, and whenever they paid, you got a share of that.
Correct.
It's very sort of like that shape. People below you, you sign up, you get a share, and then you share that with the woman above you, and then she cuts you a check. That's how it feels. That's how it's sounding, right? Ms. Tate, you, people below you, they pay, you give that money to Ms. Tate, Ms. Tate gives you a little share of it. It's like any hierarchy. All right. So now in October, you've collected $3,000. You say down here, there's a different collected amount. There's this collection number. There's your 17% you create. And then this number going forward, because after October, you no longer work for. Why is this still here?
Well, those are amounts that I closed in October or September. And I realize now that there's an error here. There's missing a column for September. So pardon, but the rest of the data on the next sheets are accurate. So again, let's say somebody bought a package for $4,800, as you can see here. And can you go back to that sheet, please, Ronna? So somebody would buy a package. The total value of that package would be $4,800.
Right,
On that day, I collected $1,000 deposit.
You should get 17% of that.
Correct. And then the next month, when the rest of the payment plan would go through, I should get 17% of that, and so on.
And it's precisely this reason why we object to this, Your Honor. This is Mrs. Ramos's opinions. That's not what it was actually collected. It's what she thinks would be collected.
Yeah, I get that. How would she know? She doesn't have the accounting.
Right.
This is a projection. And again, it is that's why my very first question, Ms. Ramos, was what happens if these people don't pay? What if everyone you signed up in October right here says, I also don't like this course I've signed up for, and they turn off their credit card and never pay? Your expected payment is not valid. She's got to actually get the money before you got to get paid.
Sure. Ms. Tate had a contract with those clients, and I understand that.
I get that,
I
right?
made the assumption, yeah.
If they don't pay on the contract, it's irrelevant to whether you get paid. Well, that's not true. She could sue them all day long. If they never pay, you're never getting paid either.
I have a question about that, Your Honor, or a curiosity, because it seems to me that, which was the case law that I was going to bring up, which is when a party who prevents or makes impossible the occurrence of a condition, the condition being paid on collecting.
Ms. Ramos, listen to the logic I'm using. Ms. Ramos, yes. If you sign up me to pay for a course and I stop paying and Ms. Tate never gets my money, Ms. Tate never has to pay you for you finding me because you didn't find the client. And there's nothing about her making it impossible. If I don't want to pay, I'm not paying. And as a result, you don't get paid because your agreement with Ms. Tate was wholly contingent upon me paying.
I understand, Your Honor. The point that I would like to clarify here is I believe that what Mr. Levy is bringing up and part of what Ms. Tate is reconciling is not that clients didn't pay or that payments didn't go through. Ms. Tate authorized refunds, which went against her policy. And so they are discounting those refunds that Ms. Tate authorized, so that is why I bring up that she made it impossible to collect.
Ms. Ramos, as a business, I don't see why she couldn't offer a refund to someone. You're literally suing her for a refund.
Well, I didn't, as a client, I didn't have an agreement, a signed agreement with no refunds. Part of our agreement as a closer was that she would send this client contract that included the terms of no refund and payments to collect to
Do
the
you
other
have that in
clients.
writing?
Yes.
Let me
of
see
course.
that. What exhibit is it that shows me that she's not allowed to offer refunds on people you fine for?
Well, I have her, I have her, client contract that of course I was privy to.
Ms. Ramos, is that a contract with you or is that a contract with a third party?
Well, I have a video recording of Ms. Tate saying that it's her response that she was going to send these contracts to the clients.
Sure, but that's not your agreement with her.
Yes, so we, in our, before I ever closed the sale, before I ever began on videos, Ms. Tate and I got on video, on calls, on video Zoom calls, and where the role was continued to be explained before I formally accepted. And part of that was that she explained to me that I would get on these calls, close them, send her the information, and she would be responsible for sending this contract to the clients that included a no refund and a payment, a responsibility to pay, excuse me. So I have a video of Ms. Tate stating that's what she would do prior to any call that I ever completed. So I understand that there wasn't a contract, like a formal contract, but there's sufficient recorded material, which I believe should be enough legally, but obviously I defer to you, Your Honor.
Mr. Levy, what's the counterclaim about?
Your Honor, and this is what Ms. Tate will explain, Ms. Cutler will explain more information about, but the reason why we had to issue refunds is because Ms. Ramos contacted clients and badmouthed Ms. Cutler and Unfuckwithable, and so those clients wanted their money back.
So you're alleging that it's the plaintiff's fault that the refunds occurred?
Yes, Your Honor.
Do you have any proof of that?
Yes, Your Honor.
What type of proof do you have?
We have the messages from the clients, and that is Exhibit 8. And I think that might be both of them. Let me check.
Client refunded withdrawal communications.
Yes.
All right.
And
I'll
Ms.
take a
Cutler
look.
can
Let me share my
explain all
screen.
of them. Sorry.
Let me take a look here. I'm going to do a little bit of, I'm going to cover up some of the names for the people that are not actually a part of this. I'm not trying to have them.
Sure. And,
I
Your Honor, Exhibit 4 shows what was actually collected.
Okay, hold on. Let's stick to this one, right? So part of the counterclaim is that the refunds occurred because plaintiff's actions resulted in those. So this is the item that was provided as Exhibit 8 by the defendant in advance. And I can see that these are screenshots, but look to be, I'm not sure. Mr. Levy, what is this?
Your Honor, I believe it is Instagram, but Ms. Cutler can clarify that.
It is School. So it's the platform we use for client communications.
Hello, I wanted to contact you, let you know I appreciate what you've put into your program, but it turns out it's not exactly what I was looking for. I want to end my time and being taken out. Wishing you the best. Okay. I'm reaching out regarding my enrollment. I won't be able to participate. I spoke with Camila as my point, didn't get any kind of paper, found myself in this kind of feud, and the recipient of many, many texts, calls, and emails from her that have made me very uncomfortable. I wasn't even told the duration of the program or anything. I'm requesting a refund for the $1,000 I put down. I'm a mama too. I make 50 a year. I want to make. So part of our complaint is that y'all took money from her without her knowing it was going to happen, or that she didn't realize that.
Your Honor, I want to.
Ms. Ramos.
Oh, I'm sorry.
I'm reading.
I'm sorry.
Right, I'm reading. I was really upset to have money debited from my bank account on the first when I had no idea that would happen. So this is a woman who's upset that she's had her money taken from her without expectation. She wasn't prepared for that. I don't know. She spoke to someone as a point person, got no paperwork. That sounds accurate since no one here does any paperwork. In the middle of some kind of feud between you both, right? So she's referring to Miss Ramos here, which sounds accurate. And this is, I don't know when this is because there's no date on any of these. Sometime in the middle of the morning, 1 a.m. All right. From one month to another, I'm asking for help. All right, so you got one person who complained about Camila. The other two just said, I don't want to be it. That's not very exciting. All right, what else is the counterclaim? So you said that the defendant refunded the money because plaintiff badmouthed defendant. That's not a counterclaim. That's why you're not giving her back her money. What's the counterclaim for?
Tortious interference with the contract, and that these individuals, and Exhibit 7 also is another example of a client who canceled after receiving communications from Ms.
And
Ramos.
am I correct that school is spelled S-K-O-O-L?
Yes, Your Honor.
Okay.
And so part of the counterclaim is that Ms. Cutler had to spend time retaining clients, and the other part of the counterclaim is that she lost clients. Both of these were the result of Ms. Ramos's bad mouthing, for lack of a better word. And
How are you valuing that?
we're valuing that as what was the cost of the program on ones who took a refund. And the other ones are the ones who were retained. The value is the hours that Ms. Cutler spent giving them free sessions to retain them.
What is the session about? My curiosity is getting the better of me. What is exactly this course about? What are we learning at the school program?
Maybe let Ms. Cutler answer.
Yeah, I can answer that. We teach women how to scale their business on social media. So we use Instagram as a lead generation. We teach holistic practitioners, service providers, coaches, and we build out full funnels for them all the way from Instagram lead generation to sales.
Okay. All right, Mr. Levy, you said Exhibit 7 was more proof that Ms. Ms. Ramos had interfered with contracts.
Yes, this is just another client that was canceled as a result of Ms. Ramos reaching out to her.
I mean, I see one of them where she's like, cool, I got that email. I'll send it to you. Grateful to be here. She didn't cancel. She's ecstatic.
Ms. Cutler,
I mean, I'm reading this one right here. This might sound a little intense, but please read through it.
and if you look
the
at
email that
exhibit,
Ms. Ramos sent her. Okay.
if you look at exhibit number 4, that lists all of the sales that Ms. Ramos had, and it breaks down the 2 people that completely canceled, which is Ms. Cole and Ms. Shanley. And
Sorry,
it lists
Mr. Levy, I was still reading through Exhibit 7.
Oh, apologies, Your Honor.
What other, now you want to turn my attention, what's the other exhibit?
Exhibit number 4.
7, 8, 9, 10, 1, 2, 3. Let me look. I don't find 4. I see 1, 3, 5. It's missing. Maybe it's out of order. No, here it is. Spreadsheet. Defendant's Exhibit 4. Y'all, they all came in. We were kind of pushing everything in together, so it's just a little bit. Okay. Let me expand and share my screen. I see a lot of names on here. Okay, but nothing to identify. Okay. All right, now, Mr. Levy, is this something that was prepared in advance of coming to court?
This was Miss Cutler gave it to me. I believe it's a business record, but she could speak to that. I don't want to mislead the court.
Ms. Cutler, I'm sorry, Ms. Tate,
Yes.
was this spreadsheet something that you had already had prepared, or did you create it to give to your lawyer to get ready for the case?
We have a spreadsheet of all paid commissions, and I just took the ones that Camila was responsible for in the 6 weeks she was with us and put it on here.
Yeah, so this is an item prepared for your lawyer for court. Okay. So this is not the actual record. This is the record put into some other form. But all right, let's take a look. So commission owed versus paid and retention time net position through November of 2025. So this is 1 month after you told Ms. Ramos to stop working. Yeah, see right here, I mean, clearly it's prepared for court. She stuck it all up here and got an hourly fee attached to it. All right, so this is definitely an exhibit for court. No worries, that doesn't mean I can't look at it. Just say that it doesn't have the same historical record that it would otherwise give me. All right, but we got people here, cash collected, commission rate of 17%. Why is this one 15%?
Can I answer that?
Yeah, that's what I'm asking.
15% was 17% was when she hit an accelerator. That's the call she referenced. We referenced in the end of September. 15% is what her commission went back to if she hadn't closed 70K in sales that month. So she did in October, so it went back to 15%.
Okay. So she was owed $6,000. Now here's my question. This is cash collected through November 1st, but it says that you paid her in October. So I'm confused about that.
Can I also answer that, Brian?
You know, you have to answer
Okay.
it. That's why I'm asking.
I just don't know who you're asking. So we paid her October 2nd to pay her for September. The rest of this would have been through the duration of October, even to the end of the month when after I let her go mid-October.
So she was owed $6,000 in October.
Correct. Like total. That's total.
Yeah,
Of what
see,
she's
that's why that's why I'm confused. Your calculation says that at the end of October, because of money collected through November 1st, you would have cut her a check for $6,000. But why would you cut her a check for $4,000 October 1st when you don't know that you've received the money?
So I think maybe there's confusion around like the payment plan. So payment plans come in. So we had people pay a payment plan in September. She gets paid 17% on cash collected.
Right. So
So
that's
I
what I
paid
assume
her.
this $4,000 is, that she was getting paid her 70% for all the money collected.
Correct.
Then
And
don't you
so
owe her another $6,000 at the end of October for money that came in on those accounts?
no, so that's total. She would have been owed an additional, whatever the difference is, 2,000 something on the cash collected in October.
Did you pay her any portion of this 2471?
No, and
Why
we
not?
have well, I mean, do we go into the counterclaim at this point? Can I just explain from my
Yeah,
perspective?
that's kind of what we're doing here. Now here's my question, Mr. Levy. I'll come back to you. So when I asked you how much defendant agrees they owed her, y'all told me 1878, but the number right here is 2471. Where's that $600 difference going?
So this is what Camila owes, what Miss Ramos owes Miss Cutler, or the company. When you
What does she
factor
owe
in
y'all?
the
Oh,
4,300.
okay, I see. All right, and then time saving her clients. Y'all are killing me here, y'all. Just so I'm clear, two women who agreed to help each other promote their businesses through social media and scale up have no signed contract whatsoever. Just so I'm clear, a company that purports to sell a package to help women scale their business did not have a written agreement with someone they hired to do sales for them. Mr. Levy, is that an accurate statement?
Yes, Your Honor.
Okay. And now those two women have come to the court for confusion over an illicit problem that they could have solved through better accounting and, I don't know, some of those lessons they were trying to teach to each other.
Yes, Your Honor.
And now they are both creating issues, including time and effort and hassle they've both spent, when all of this could have been resolved if they had made a clear, written, independent contractor agreement in the get-go.
Yes, Your Honor.
All right. And now they're arguing over how much is actually still paid. Do you have any proof for me of what Miss Tate's company brought in from those commissions for the clients that Miss Ramos found? Is that the
Miss
spreadsheet I just saw?
Pardon me, Your Honor?
Is that the spreadsheet I saw, the actual money collected from those cases?
Yes, Your Honor.
And per that calculation, defendant says 1878 is still owed to her, but then y'all are seeking to get money from her as a counterclaim for having to go back and talk to all those clients that she sent the email to.
Yes, Your Honor.
Ms. Ramos, I saw some messages in the school platform indicating you had sent an email to some of those parties. Is that accurate?
Your Honor, I had sent a text message, and I'm happy to explain. So
You don't have to
No.
explain it. I'm just asking
Well,
if you
there-
sent
yes, Your Honor.
it. Okay, so you sent it. All right. So you sent a message to some of the other people and said, I'm disappointed and unhappy with the situation going on. And as a result, they reached out to Ms. Tate and said, what's happening? I've seen those messages, Ms. Ramos. That's a fact, right? I just read them from those people in school saying, yeah, I got this long message. Let me show you what Camila sent me. Sounds like y'all have a lot of drama. That's true. Your messaging those people caused them to call Ms. Tate and say, why am I hearing from Ms. Ramos like this?
Your Honor, I would like to bring up that regarding the defendant's Exhibit 8 with Ms. Cole, I have a record that I also submitted of my text message with Ms. Cole. The reason I reached out to these clients and what the message actually said, which was largely omitted in that screenshot, was these women paid thousands of dollars to be in this program. There were certain gaps in this program that I made Ms. Tate aware of and that I created solutions for. Ms. Tate and I were in constant communications on improvements to her program. We were talking about me being a coach, I was going to help those women when I closed them with these gaps. I thought that I could help them. When I was terminated and I could no longer do that, I sent this message offering to share it with them, information that I thought was awesome, that could help them succeed in Ms. Tate's
Ramos,
program.
The things
Yes.
you pointed out to them were things that you found to be flaws in Ms. Tate's program.
Correct. And these are flaws that I brought
That
up
would
to Ms.
be,
Tate
Ramos,
and that Ms. Tate
Ramos,
agreed were flaws.
that would be considered intentional interference with the business contract.
Your Honor, I
Which
had
would
no
be a sufficient reason, Ms. Ramos. You're supposed to know these things. As an adult entering into business, the law says you're supposed to learn them. I know that's frustrating. I'm trying to help you out here.
Well,
if you
hold on.
sent an email to clients that Ms. Tate introduced you to, bad-mouthing Ms. Tate's business practice, that would be a reason for Ms. Tate to fire you, as she did in October.
Your Honor, these messages were sent post-termination. Again, I had access, correct, and I had access to these clients because they were also my colleagues in the program. And I would also add that nothing that I said was defamatory, and everything that I said, I had previously brought up to Ms. Tate and she agreed.
Okay,
These
let me ask
were,
you this, Ms.
these
Ramos.
were,
You,
okay.
you brought up a timing question. Mr. Levy, did she send that message before or after Ms. Tate let her go?
I don't know the facts, Your Honor. I would
Ms.
defer to
Tate?
Ms. Cutler.
Yeah, she sent the message after I let her go.
So then that's not a reason to let her go. Why'd you let her go?
When I requested that she send me sales calls for review, which is how I review and quality assurance on sales, she refused to send over the sales calls. And after that, I let her go.
And do you have anything in writing that requires them to send you those sales calls?
No, and everything you've said, I completely agree with. Like, I'm completely changed the way I do business from this situation, and I was an idiot at the time.
I won't disagree that I feel disappointed in everyone's actions here. As women, we're all strong with it, ladies, but you're all really disappointed that none of you bothered to put anything in writing, and you're spending thousands of dollars to try to be business people, but you're going about it, frankly, irresponsibly.
Agreed and heard.
And that you're trying to coach and school other women and get them to do this is frustrating and disappointing as an individual. Legally, right? I got to figure out your situation because you've got a handshake agreement for a promise to be paid, and I don't know when to be paid. I mean, honest, the very first thing I wrote down when you told me how you're getting paid, Ms. Ramos, was, don't we have a statute of frauds problem? And Mr. Levy is shaking his head immediately. There's a huge problem with this. Now, luckily, it didn't go on for more than a year because within the first month, Ms. Cutler said, stop doing this. And Ms. Cutler, there's nothing that says she can't just fire you at will. You're an independent contractor, so she doesn't have to have a cause. In fact, even if you had been an employer-employee relationship in Texas, Texas is an at-will state, so you can be fired for any reason, except a discriminatory purpose, right? But like, I don't like you cheer forth the World Cup. I could fire you for that. That might be nice, but it's not illegal in Texas. So the relationship between the plaintiff and the defendant was just that, arm's length. You're an independent contractor. You could terminate it at any point. The question is, if you terminated her without cause, and I would say that if the reason you terminated her was you didn't see her sales calls, but she's not required to give them to you, I don't know that that's for cause. I think it's just, okay, I don't want to do business with you anymore. That's not how I'd like my independent contractor to work. That's reasonable, but she's still got to get paid for the work that she had done. So she still needs to be paid, and there's no dispute whatsoever that she's owed at least $1,878. So we got that down. And then Ms. Tate, or Ms. Cutler, you say after that, these parties still owed money. Did they finish paying out their accounts?
No, however many of them I wrote on that sheet either stopped paying. However, it was that two people who wanted the full refunds. I gave it. One Nadine, who is in Camilla's exhibit, stopped paying due to sickness, admittedly unrelated to Camilla. So however many there, we show you when their payment plans stop. The agreement that we had either verbally made or in WhatsApp message, not in contract, was cash collected. I did not collect the cash that she is saying I collected.
So Nadine paid 1,000 in September, 633 in October, 633 in November. And never paid
Your
anything
Honor.
further. So the commission you calculate is 385. So altogether, you calculate commissions owed to the defendant, to the plaintiff of 9,223. And then you less what you paid her. And so this second page says there's a $5,000 commission owed. I'll share my screen because this is y'all's exhibit. All right, so here's the pages from the defendant, exhibit 4. Here's the first page. But this is the second page, which is more complete. And this one is the exact same names. They're just not in the same order. But like, for example, you mentioned a person named Nadine. So here she is. She's down here this time. In September, she got signed up by the plaintiff, paid $1,000. In October, she made a payment on it. Miss Cutler lets the plaintiff go. Plaintiff sends an email. Regardless, Miss Nadine, she pays another $633, then she stops. All of these have payments going through January, or at least some of them. And there's a total amount collected. Here's a refund that's given for one of the cases. But over here, commission owed, $9,233. And then here, what is she owed versus what she claims? Less commission owed to her for comparison. So here you're getting a much different number. You say altogether $9,000 is owed to her. She's actually been paid $41.39. So here the number is $5,000. So is that what she's owed? Because that definitely begs the question.
This was calculated, it looks like, based on Ms. Ramos's numbers. For
No,
comparison.
Ms. Ramos says 11,000. See, for comparison, she claims 11,000. This is y'all's sheet.
Oh, I think the distinction, Your Honor, is that some of these commissions were collected after she no longer worked there.
Yeah, that doesn't mean she's not entitled to get paid.
Well, our
Nothing in
position,
their contract says she's not still entitled to be paid. The fact that she doesn't work there anymore, she's still closed on the deal at the time. They don't have anything in writing that says you have to still be an independent contractor, keep getting paid. Any reasonable person would say you owe me the money. I'm the one who got you that contract in September, and you got paid on all the way through January. Where's my 17%? All right, so here's a new number, 5,093.
Your Honor.
Who is that?
It's Ms. Ramos. I just want to point out in this exhibit, it goes through January of 2026. Whereas there are still payments that Ms. Tate received in February, March, April, May, and actually until August. There would have been as far as the prospective payments expected.
Ms. Cutler, have you received additional payments on any of these accounts after January of 2026?
So most of our payment plans are 4-month payment plans. One of them was 6 months, but I upsold her into a different program. So it's getting kind of logistical, but there's one Launchpad at $4,800 and one is Breakthrough at $1,222. The only one who paid additional after that would have been Michelle, where's her name? Michelle McKay, the first one. So Camila is owed the commission of the thing that she sold. And the thing that she sold was the 4-month payment plan at $4,800.
So I'll ask it again, Ms. Cutler. Have you received any money beyond January of 2026 for clients that Ms. Ramos secured in September and October?
Yes, for Michelle McKay.
And how much money have you received since January of 26?
I'd have to double check that.
Go ahead and pull it up.
Okay.
and just to clarify, Your Honor, our position is not that she's not owed the forward-looking money because she was terminated. It's because she actively jeopardized the business. She forewent.
That's the counterclaim. That's the counterclaim that she then interfered. So y'all owe her the money. What you're saying is that she owes us money as a result. It could wash.
Well, our position is that because she actively went against the business, that she shouldn't be entitled to those commission payments.
And I'd say that's self-helping, Mr. Levy, right? Otherwise,
I just wanted to clarify our position.
I got it. Your client self-helped. Rather than pay her and then sue her for refunding the hassle she spent, she said, I'm just not going to give you the money because I've spent a lot of hassle trying to recover the clients that you badmouthed me to. That's a self-help provision. It's not the legal way we go about it, but that's essentially what the plaintiff, what the counter plaintiff is trying to do or did do. All right. And I'm just saying, though, that she owes her something. So let's figure out that number, and then we'll determine if she's entitled to anything because of Ms. Ramos's interference. But let's figure out what Ms. Ramos is owed, because that's the original claim. So right now we've got her at $5,093 plus whatever 17% comes from what was received from that account in February or March and April. Any amount you still received from these accounts after the spreadsheet ends, Ms. Ramos would be entitled to a commission on those.
But just to be clear, she doesn't receive a commission on something when the client's working with me and continues to work with me.
Ms. Tate, I don't just, well, that's what my question was. You, in this spreadsheet, you have those numbers in September, the things that Ms. Ramos secured. So she's only entitled to 17% on those as they're paid. If after you were going and say, January, one of those people signed up for a new package, Ramos doesn't get 17% of the new package because she didn't secure that. But if the person is still paying on the original package, Ms. Ramos gets 17% of that. So that's what I'm asking is, have you received any payments on the original packages that are not reflected in this spreadsheet?
No.
So that's everything.
Yes.
Not
Everything.
You haven't got any money after January on these accounts that Ms. Ramos secured?
Not to my knowledge. I did the calculations and I believe that's correct.
Do you believe it or can you swear to it?
I believe it.
All right. Now, that's Ms. Ramos's claim in chief, right? That is her commissions. She sought 11,000. Y'all have acknowledged a good portion of that, 5,093. And that is through January. Ms. Ramos, how much of your claim is for money that would have occurred after January 2026?
So I can do the exact math, but I want to point out the clients that perhaps Ms. Tate can look in her records for. I've got Palmas Nadar, that's payments collecting through April 2026, as well as Michaela Rager, Katie Magelstein, Emily Baldwin, Lindsay Thompson. These are all payment plans that were established.
Ms. Ramos,
yes,
those names are all on the spreadsheet. Ms. Tate just swore in court that they didn't pay anything after January. I know what you're saying is you believe they did. I don't have any proof one way or the other. She just swore under oath that they didn't give her any money. If you find out later that's not true, she will have committed perjury. But unless you have evidence or proof, like you've got a hold of one of those clients and they said, yeah, I absolutely sent her money last February. What you talking about? That is your position. But her sworn statement says that this is an accurate reflection. She has acknowledged her statement today and her sworn evidence that she owes you $5,093.90. That's not in dispute anymore. You are going to win that amount of money. Now the question is, do you owe her any money for sending that email after she terminated you?
And just to be clear,
and we are not done with your other parts, right? You also wanted back a refund of your class and the $400 for the coaching and $1,500.
Right. And I couldn't have, well, okay, thank you. Yes, I understand, Your Honor.
Now, you were supposed to be paid $400 for coaching, correct? Ms. Ramos?
I paid, $400 for coaching, correct. Thank you.
Okay, and did you perform the coaching?
The agreement was $1,600 a month. I performed one Thursday. And so out of fairness, I'm asking for my prorated share instead of the full month.
All right. Ms. Cutler, is that correct? Did Ms. Ramos perform one time as a coach for your service?
She did one coaching call.
Okay. Was there any understanding of how many coaching calls for $1,600?
4, so there's 4 per month.
Okay. Oh, 4 per month?
Correct. So every week.
Okay, all right.
And also I'd like to amend my earlier answer because as you were talking, I just calculated Michelle McKay because I wanted to
Okay.
see the difference. The difference is 1614 from what she sold her in. So she sold her into something at 7, hold on, sorry, 1 second. 7,650, and we collected 1614 more than what is stated on that document. And the reason why is because she upsold into a different thing.
Who
So-
upsold? Ms. Ramos upsold her?
I did.
So then Ms. Cutler, my question is the extra, is the additional 1614 paid by Ms. McKay money that is owed to, that would Ms. Ramos get a 70% commission on that? Or is that money she paid as a result of your upsell?
The upsell was later in October. That would have been a result of Camilla's actions. She would have gotten an additional 17% on 1614.30.
Fantastic. That means you get an extra $274.38. All right, thank you. All right, we got a coaching call. And then Ms. Ramos, you were seeking a refund of the course you signed up for, and that was $44.10. And I can understand that there's stuff to the package. Now, you signed up for the course a few months prior, though. I think, was that in April? Do I have that in April? In the
April
spring.
16th, Your Honor.
Okay. And so April through May, May through June, June through July, July through August. Were you participating in the program?
April through, I believe, June. I had a really hard personal situation in June, a pretty violent experience, and I asked Ms. Tate if I can pause on the program so I can focus on that.
And did she agree?
Yes.
Ms. Cutler, is that accurate?
Sounds correct.
Okay. Ms. Ramos, did you then ask to start the program up after June?
Correct.
Okay, and when did you begin the program?
I commenced, I believe, the 3rd week of August again.
How long was the program supposed to last?
Access to the community and the platform was for a year. Well, I mean, it's assumed that I could talk to the women that I met there indefinitely, I would say.
Here's what I kind of need. I need to know what you paid for so that I can determine what you got out of it and what is remaining. So when you spent $44.10, did you have an understanding of what you were getting, like 5 coaching centers, 24-hour access for 6 months to a site? Like, what did you pay for?
Yes, it was 24-hour access to the site for a year, which included, that site also includes the community and also access to 16 group calls per month. And that access to the group calls was only for 4 months.
So you got 16 group calls each month for 4 months?
Correct.
Okay, so you got 1 year, 24-hour access to the platform. Each month for 4 months, you're going to have 16 group calls. What else could you do?
I believe that's it.
Okay. All right. Now you signed up in April, but almost immediately you had something interfere in life, which can happen. And so you asked Ms. Cutler if you could pause the program. When you asked to pause the program, were you pausing payment, or were you wanting to extend your time and therefore sort of delay opening your membership?
The time. I had already paid in full by that point.
All right. Did you already have access to the online portal in April?
Yes.
Did that?
I mean, not prior to April, but in April.
When you paid,
the
you
access
got
began.
access to it. Okay. And then when you
Yes.
asked to pause your membership, were you still able to access the program through April through June?
Ms. Tate said that she would continue to give me access through that time.
And how about the group calls? Did you participate in any of the group calls between April and June?
No.
Okay. How about after the pause? When you came back, now we're in July. Did you participate in any of the group calls then?
August, you mean, Your Honor? I recommenced in August.
In August. Okay, how about beginning in August? Did you participate in any of the group calls?
Just for a little bit, and then my role as a closer began, and I was also asked to be part of the calls as a closer, so that we get into sort of really muddy territory there.
All right. But you had access to it and could utilize the program that you had paid for at that stage.
Right.
All right, so that's August. In September, same thing. You could access it. You could use the group calls. You could do the platform.
Correct, Your Honor.
And I understand that you might be having sort of two hats at some of the meetings, which
Sure.
gets a little bit
Yeah.
strange. I know. I do the same thing. Sometimes I'm both a member and a board person. I'm like, which one am I voting for, right? So I understand. All right. So in September, you're still doing everything like normal. How about in October?
In October, my access to the platform was removed on October 16th when I was mid-sales call, but as a client, it was removed that day.
And so it's sort of two things. You were removed from access to the portal because she stopped you being an independent contractor, but you should have had access as a customer, and that was taken away from you as well.
Right, Your Honor.
Were you given any information about whether you could access the group calls and continue on going for the next year?
No, Your Honor, we didn't discuss that.
Okay, so from November through April, you did not receive the benefit of the thing that you paid for.
Correct. And I also asked, which was part of the defendant's exhibit and her screenshots conversations with me, but I did ask if we could align on when the end date would be, because I recognized that it was kind of all funny, but we never got to that.
Okay. All right.
Your Honor, our exhibit 5 shows that in October 16th that Miss Ramos actually, or maybe that's not the right exhibit, I apologize. It is. It is, no, that's not the right exhibit.
Mr. Levy, did Ms. Ramos continue to access the platform after November of 2025?
Miss Cutler would be able to answer that.
So after October of 2025, after we had a call, I took her off the school platform, and then she said, hey, I'd like to continue on the school platform because I paid for it for a year. And I said, that's totally understandable. Let me go ahead and add you back on. That same day I added her back on, and she churned herself the same night. And that's been confirmed by school's back end. Their tech have confirmed that.
Okay, so you say that you put her back into the portal as a student.
Correct.
And what did she do?
She removed herself that same day.
Ms. Ramos, is that accurate?
Your Honor, I notified Ali of being taken out as a client. She invited me back in. I initially went in, but I didn't leave the program until she sent me a cease and desist to not communicate with the clients. I believe that was 2 days later on October 18th. Perhaps the records that school has is from her original churning, I believe the term is, of taking me out on the 16th.
Okay, so Ms. Ramos, she took you out of the portal. You said it was mid-call. Ms. Cutler says that you then contacted her and said, hey, I still want to use the portal as a student. I paid for it. And that she agreed and gave you access.
Invited me back, correct.
Okay, so that's true.
Correct.
Since you were invited back, but you're saying that after you were invited back, you then got the cease and desist letter from the lawyer.
Correct.
Okay.
From Ms. Tate, it was 3 letters, sorry. Sure.
Did you, and this is where I don't know, did the lawyer you called or used, did they explain to you any of the distinctions between you as an independent contractor and you as a customer, and where your rights and responsibilities lay in each of those?
Correct. And they advised me just to be safe, to cease all communication. And so that's what I did.
Right, that's community, but how about using the thing you paid for, the portal? Or the group calls?
No, Your Honor, at this point,
Okay.
that wasn't, there was so much, not to bring in personal
All
things,
right.
but I was
I
in a
can
very,
understand it. I
I
get
just
it.
needed to get paid. Yes.
There's a confusion and a hassle in that one. Or I can see, I can understand how the parties would be uncertain of what to do in those situations. All right. So let's go back. That's the refund, coaching, commissions, and then you hired a lawyer. That was the lawyer there in Florida who gave you some advice. I can understand that. And I will just say, both Mr. Levy's advice that I could see he's given his client and the advice that you got from your lawyer, well, those are all pretty standard things. All right. Got the platform. Put back on, chose not to use it. One on there, one on that one. We'll see. All right. I think that resolves everything I've got on the plaintiff side. How about Mr. Levy? So now the counterclaim. The counterclaim is about the interference alleged by Ms. Ramos with the contracts that Ms. Cutler's company had with all of those people. Correct?
Yes, Your Honor.
All right. And there's not really any dispute, or at least I understand that after Ms. Cutler notified Ms. Ramos that she was no longer going to be an independent contractor, Ms. Ramos did reach out to several of those people and sent them some communications. Do you have a complete set of the communications or a complete message that Ms. Ramos allegedly sent? Because I saw kind of versions of it in those screenshots, but I don't know if there's like a more complete one.
That's what we have, Your Honor.
Okay, which exhibit is that? Or I'm sorry, Mr. Levy, is that all y'all have are those screenshots?
Yes, Your Honor.
All right, let's go back. Which one was that? That was the school platform record? Or no, the thread with Cutler and Magelson,
Yes. Which is,
exhibit 7.
yeah, exhibit 7, Your Honor.
Okay. All right, I'm going to share my screen and let's just all, well, I'm going to read it out loud and y'all can look along with me. Okay, and these are messages taken from the school app, right? Isn't that what we established earlier?
Yes, Your Honor.
Oh. Okay, and then there are 7 pages. Do any of them have timing on them, or dating on them? This one says October 18th, so there's a date. None of the others do, so on or around then. All right, let's see. I wanted to reach out and let you know Camila's no longer. So this is the defendant or the counter plaintiff responding to one of the clients saying, hi, I wanted to reach out, let you know that Camila is no longer here. You can handle it through me and our team inside. If you have questions, make sure you're supported. You can book here. Okay. Looking forward to it. And then she goes, I did receive a long text email or a long text from Camila earlier today. All right. All right. Is that a terminal arc, a sacral generator? I don't know what that is. All right, so this is at the bottom here. This is the text message that she says Ms. Ramos sent.
Yes, Your Honor.
All right, so this might sound a little intense at the start and it's long, but please read through it if you can, because I want to be transparent in the the trust you placed in me. I was let go by Allie. Greater sales cost to me is just training material. You share personal things with me. So this is just a continuation. It's just sort of cut off. That said, I still believe in her program, one that made it flow and feel natural. I was so excited about it and offered to share the system with her. She declined, referencing profit margins and suggesting I should prove my, and then it drops off. So there's something that's missing there, right? Many of you
No, I
trust.
think yeah, it continues there.
Yeah, that's. Then again, there's no agreement between the parties that she can't poach. There's literally nothing that prevents Ms. Ramos from doing this, right? Typically, I see that in these kind of independent contractor agreements that you promise, like in a hair salon, I get a lot of those. But to my knowledge here, the parties just like kind of had a very, very vague understanding and they only talked about commission rate. So while in other situations, this kind of action might be bad, it's not strictly prohibited at all. It's just, it's not good, but she absolutely says, hey, come to me and I'll do it for free. All right. And that's the final page.
Your Honor. Your Honor.
Well, Ms. Ramos, it's Mr. Levy's turn at the moment.
I'm so
All right.
sorry.
So I can see that she sent a message to the clients. And there's absolutely no doubt that it took Ms. Cutler time to respond to those things, but
It's the fact that she's asking for a commission when she was responsible for losing that commission seems to be that's what our issue is.
but Ms. Cutler only has to pay her for things she got paid on. So she's not losing those commissions. She's not suing. I would not award Ms. Ramos money on a commission that Ms. Cutler did not receive payment for. That was one of my very first questions to her. What happens if she never got paid? So it may be true that Ms. Ramos, by doing this action, caused people to cancel their contract, but the punishment to Ms. Ramos is she just doesn't get any commission on that. Instead, she did twice the work for nothing.
Sure, but there is a substantial loss to Tate US LLC because of that.
Has she a substantial loss? Because what I saw from the spreadsheet is that she pretty much convinced everyone to stay. And in fact, some of them, she sold a better package.
There was at least two
She collected
people
enough money that she owes $5,000 in commissions to Ms. Ramos.
on Exhibit 7. There's two people that Exhibit 8. No. Exhibit
Take a look at 8. I just read through 7.
4. I'm sorry. The first page of Exhibit 4 shows the two people, Rachel Cole and Linnea Shanley, who completely took money back out of the program and got full refunds after receiving that message.
So she refunded them their money. Did she reduce the commission owed to Ms. Ramos in her spreadsheet?
Yeah, I believe that's the
Like,
case.
if Ms. Cutler was paid, let's say she got paid $1,000, and she's like, all right, I'm gonna give $170 to Ms. Ramos for a commission. And then the next month that client calls and says, I'm canceling because Ms. Ramos badmouthed you. And Ms. Cutler sent back the $1,000. I would agree that Ms. Ramos needs to give her back $170 because it's her fault that the client refunded. And she doesn't own a commission because essentially Ms. Ramos and Ms. Cutler never got paid. So
Correct.
for these two, Ms. Cutler refunded $1,000 to each of them. Rachel Cole wants $1,000 back.
I'll let Ms. Cutler explain because I don't know the facts. I don't want to testify. I only agree to testify on as attorney's fees.
I understand that, Mr. Livy. I appreciate that.
I definitely do not want to be misleading.
I appreciate that. But Ms. Cutler, I can see there are two requests to withdraw and a refund. One of them is from a woman named Rachel Cole. She's the one who says, I didn't know y'all were going to take 613. I wasn't prepared for that. I want my $1,000 back. And the 613. So she wanted back 1613. And then the other one was from a Linnea Shanley.
Rachel Cole had put $1,000 deposit down and then the 633.33. She was upset about the second charge, possibly because it hadn't been communicated correctly.
Yeah, and I can understand that, and that happens. And I'm not saying that y'all didn't communicate correctly. These things happen all the time. What I'm asking is that did you refund the entire 1613 back to Ms. Cole?
Correct.
Okay. And how about for the other one here, Ms. Shanley? Did she receive any type of refund?
Linnea Shanley was credited, not refunded. So we credited that 1633 to her account. We're like, hey, when you want to come back in, this is good for a year. You will be able to pay the duration. As I said, Camille said, I do have contracts for them, so she can finish the duration of the payment and use that credit for it.
All right.
I think the point we're making is there's a 4,500 minus 1633 is 2,867 that the company lost as a result of those people dropping out of the program.
Well, only one of them she gave the money back. The other one she got to stick around.
the date of her credit is now expired, so she's not coming back.
Yeah, but y'all got her money.
Less than a quarter of the money.
All right. But Cole, you refunded back all $1,600.
All $1,600, correct.
All right, so of that, 272 would have been the commission that got paid out to Miss Ramos from it. That's 72, that's 17%.
Yes.
All right. All right.
Oh, and sorry, just to make sure, I want to amend what I said earlier because I was frantically looking up to make sure I'm not committing perjury.
Okay, I appreciate that.
Okay, so I looked up past January to make sure. It gets a little muddled because there are people who continue on with us after the date that Camila signed them. So with what Camila signed them, this is what I can see. And I hope I'm right and that I'm not actually giving her credit for something we upsold them to, but this is what my record said. For Thomas, Michaela, the names she mentioned, Emily, Baldwin, Michelle, Katie, and Michelle N. With all of the money that came in it was up, some of them came in January, she's owed an additional 1690.81. And that I can verify, hand to God, I have done my research. There's nothing left on the table here.
All right, so that's also owed to her?
Yes.
All right. So that brings me to 67.87, 1 penny. All right. Now, I'm so sorry. I'm going to say you, Miss Camilla, Miss Cutler, Miss Cutler.
Yes.
Now I definitely see that you spent some time having to go back and an effort with the parties after Ms. Ramos sent that email. And I've seen the emails where you offered a refund, you offered a credit. Were there any other things that you have that would show me sort of the efforts or the actions you had to take as a result of those emails that went out or that text message?
Yeah, so there was however, she signed 15 or 16 clients. So I had to send 16 different emails, track them down either via school, email, or text message. And if they didn't respond, I had to call them. And then when I got in communication with them, I offered them all a 1-hour free coaching call because I was like, look, this is really messy. I'm really sorry about that. I know we look unprofessional. Let me make this right. And I'm going to take a 1-hour coaching call with you. And for 9 of those women, I took a 1-hour coaching call. Now I know that in the eyes of the court, like people pay me $997 for a 90-minute business consultation. And in the eyes of the court, that is like far too high and I'm not asking for that. But I did do 9 hours of one-on-one calls with people who would not have had that option.
All right. Anything else?
For me?
Or related to the counterclaim, any other evidence you want to show me? So I see the information related to her contacting the parties after the fact, and then and then certainly, offering to have them come to be with her.
Yeah, I think that it would be probably important to say that like the most important thing to me at the beginning of this was the withholding of my sales call. And as you say, we didn't have a contract, but the messages, WhatsApp, written and otherwise, that we have between each other, she was aware that she was doing work with my business, my leads, my CRM, my system, my pitch, my sales call. All of it is our material. And so the whole contested idea that she owns those sales calls is not true because she wouldn't have had those sales calls if it wasn't for my business.
I'd say that is where a contract just explains that clearly to everyone. A reasonable person could argue both sides of that, and that's why, as the judge, I'm glad I'm not having to decide that.
Sure.
But I think there are many ways that those can be written. So if it's really up to what's reasonable to both parties, reasonable can be pretty broad. But okay.
Oh, and can I add one more?
Shared by both parties, Your Honor.
I'm sorry, Mr. Levy?
They can be shared by both parties. They're digital, they're data, so both parties can have access to them.
Oh, yeah, I thought you said they can't be shared, and that's why I was a bit confused. I was like,
my apologies.
No.
It can be shared.
Hard to hear some of that. All right. Yeah, no, I all right. Anything else on the counterclaim?
Just the attorney's fees.
Okay.
And to date, we have $18,670 in attorney's fees, and that was before today, not including the trial.
Is that just for this matter?
Yes, Your Honor.
Oh. All right, would you like to make closing statements now? Ms. Ramos, you're both the plaintiff and the counter plaintiff. So as kind of the way we would do this is you would get to give me a kind of a summary, like a wrap-up summary for your side. Mr. Levy gets to do the same thing. And then technically, Mr. Levy, you both get a chance to kind of have a final bite at the apple because you're both a plaintiff of some sort. But let you both give me a final statement and then I'll make some outcomes. Okay, go ahead, Ms. Ramos.
Your Honor, prior to a final statement, I have some points that I'd like to contest regarding what was brought up that I've been waiting for.
Go for it.
So, first of all, regarding the recordings, I was happy to share access to them during the term that I was with Ms. Tate for review. But when Ms. Cutler, excuse me, requested them for training purposes, that is where I drew the line. Because the calls took place between, I didn't think it was appropriate, and legally, I was in Florida where the calls took place. Florida is a two-party consent state, and without consent, they cannot be used for-profit per Texas law. So it gets kind of confusing with that, but the calls were requested for training, and ownership of the calls was requested, which is where I objected. Ms. Tate was creating a video training program for closers, and I also, the script that I used on the call was proprietary. So even if they are commingled assets, they wouldn't be able to be used for the for-profit training activities. And that's why I refused. I also want to point out that in Exhibit 7 of the defendants with Ms. Katie Magelson, it shows that Ms. Cutler offered free calls to her clients prior to knowing about any text. This was an action that Ms. Cutler offered independently of anything because of the termination of someone that was a coach and a closer. Sorry. And also regarding the refunds that were issued, there's no evidence that the cancellations were directly due to me. On the contrary, what it shows is that Ms. Cutler agreed to refunds. She went against her own contract. She made that choice and she actively had to sign on and give those refunds. And I also have, I also want to point out that for the claim of tortious interference, there has to be. Oh, okay. Okay. Well, if that claim is not there, then that's okay. And then I would like the opportunity to review when I listed the clients that I had records of the payments going through. I appreciate Ms. Tate going back to her records. I would appreciate the opportunity to review all clients because I was only able to list a few examples and then I had to stop speaking. So in order to reconcile in this trial without having to then appeal, I would appreciate the opportunity to reconcile all of the ones.
You should have requested discovery before the hearing. We're in trial now. I have to make a decision. I can't wait for y'all to go and look for your financial records. That's something you could have requested discovery, and I would have had her turn over her financial records and vice versa, and then we could have sat and compared those.
Okay, then what I ask is that Ms. Tate, I guess, swear under oath that there aren't any other payments or that she doesn't want me to let her know what they could be so that she can make that true statement.
All right, Mr. Ramos, how would you respond to the allegations about you emailing 15 to 16 of the defendant's clients and bad-mouthing her and offering to do service for them?
I disagree that it was bad-mouthing. I have the full record of what I sent and specifically to her? Yes, I did. Actually, I'm
tell them that you were
concerned
about her business practice and offer to do services for them instead?
I I brought up gaps that I had also brought up to Ms. Tate that she agreed were gaps, that I have a video recording of her agreeing were gaps, and that I had solutions for. I want to be really clear. These clients paid thousands of dollars. Many of them had pressing financial circumstances that I was privy to. I felt that I was doing a good ethical thing by offering them something that could help them succeed in her program. If you review the message, it goes at the end, it really clarifies that. I also say, I'm not trying to pitch, I'm not trying to sell you anything. Like I have 3 other businesses, Your Honor. They have nothing to do with this. I have no reason to compete with Ms. Tate, even though I would have had the right to. And then in further conversations, and especially with Ms. Cole, I share with her like, hey, this was a huge investment for you. I would love to help you take advantage of it. I wanted them to succeed in Ms. Tate's program. I want Ms. Tate to succeed. I want everyone to succeed. And I made that clear in all of my text messages. I thought it was a very objective and positive message. But I understand that there were things that there were gaps. I didn't say anything defamatory. I didn't say anything that wasn't true. Anything that I didn't already have brought up to Ms. Tate. You can see that in my exhibit F1. I message Rachel Cole. It goes through our entire conversation. Also, just where I let her know what her payment plan was and that she would be receiving a contract from Ms. Tate. I also have, of course, a text message where I let Ms. Tate know to send the contract. Mr. Levy's most recent response filed said that they had an active contract with Ms. Cole.
I'm looking at your exhibit, Ms. Ramos. You said
F1, thank you.
F1. So this is an email
Yes.
chain that starts, it's like a text
Page
message chain.
Text
13,
message.
I think, is when she sent the message.
I'm sorry, Mr. Levy?
Page 13, I think, is the message that you were asking for a full copy of.
Oh, okay. Are you looking at this as 17 pages? Do you have that?
Yeah, I'm looking at F1.
Okay.
And I'm saying on page 13 of 17 is the message she sent.
Okay. I'm getting my bearing on what I'm looking at here. So I can see at the top of page 1 that we're in September of 2025. And the first one in blue, it appears to be the plaintiff, Camila, contacting one of the third parties, one of the clients that she'd signed up. All right. And
It goes through our entire, sorry, I'm sorry.
17 pages. I gotta read it and see what it is you sent me, right?
Thank you, Your Honor. Thank you.
So I see that she's responding, hey, Camila, thank you so much. She talks about money issues. All right, I see in September, you're giving her 7 steps to go ahead and pay. I'm on page 8. I'm still reading this chain of lines, right? Lots and lots and lots. Oh. Okay, so she attends a class, she learns a lot. Didn't make this class. Good morning. Okay, so I see the change. So all the messages are good, and September 15th, final message from the plaintiff is awesome. Sounds like you're ready for today's call at 1 p.m. Okay. And then we jump forward in time quite a bit because the next message is October 17th. So we are now a month and 2 days later. And this is the long message from Ms. Ramos.
Correct.
It's pretty tepid. Okay, and then I see where you tell her you can't talk to me more because she got the cease and desist. And it may lack legal merit, I don't know. But And upon this caution, you're like, I'm just gonna wish you the best and say so, bro.
Right.
And then like 2 weeks later, she says they took out money. Did I sign anything? And you're like, I can't talk to you. All right. All right. Anything else, Ms. Ramos?
Mm. Just the last piece about, I guess it would be a cross-examination with Ms. Tate and asking her to, about the clients that are pending, let's say. But other than that, I appreciate this opportunity.
What questions would you like to ask Ms. Cutler related to the outstanding payments?
I would like to ask Ms. Tate, let me pull up my exhibit so I can follow along. I would like to ask Ms. Tate what happened to, I believe it's Lauren Fleischman as well, which was a pretty significant commission, again, through the months that followed. Let me pull it up. Let me follow really quick on a Google sheet. It's a little bit easier. Excuse me. Okay, so I have through March, I believe Ms. Tate already reviewed on this. Linnea, Michaela, Katie Magelson, Nadine Damian, Emily Baldwin, Lindsay Thompson. There should also be Michelle Nugent and Michelle McKay. And then
We'll do it this way. Ms. Cutler, Ms. Ramos, let's look at this communication together. All right, so here's the spreadsheet prepared by Ms. Cutler for court. Ms. Cutler?
and yes, sorry.
Ms. Cutler, this first case in here, Miss Michelle McKay, and so that she paid all the way through January. Did Michelle McKay make any payments to you as a result of the contract signed that Miss Ramos found? Did you get any payments on Miss Michelle McKay's account after January 26?
Yeah, so the number I restated earlier, I included Michelle McKay. Additional payments do you want the total or do you want the commission?
I guess give me both. What's the total that you got after January?
Total is 1614.3.
All right. And then how about for Kush? Well, I'll go back and we'll do the 17%. What about for Kokushkova? Did you get anything after September the 4,800? That is the full amount, right? That one's done. Michelle Wynn, looks like she made payments. Did she pay anything after January 26?
Yeah, I have a 633.33 payment.
Okay. How about Olivia?
She's asking about after, Allie.
Yeah, I have one for February, or maybe it was March. Some of these payments delay and I have to go chase them up, and that's why it didn't show. So February 633.3.
Okay. How about for Olivia Greenwald? Did she make any payments after December?
No.
All right. Brittany Dooley, any payments from her? Although I think she paid the full amount. That's why they're all done. Johansson paid up front. How about Baldwin? Did she keep paying after January?
Yeah, I have Emily Baldwin was an additional 1,900.
All right. And then Magelson, did she keep paying?
Yes, 1899.99.
Rager, did she pay?
Didn't we count her already?
I see 1,630, and then I see she skipped December and she paid in January.
Michaela Rager. Michaela. I wrote down 1899, but I thought I already said that.
We put that one for Magelson.
Oh shoot, sorry. Both of them are 1899.
Okay. How about for Clemens? She made 3 payments. Did she pay anything after?
She stopped paying.
Clemens stopped. Okay, how about Namdar? Did she make any payments afterward?
Palmas did an additional, by the way, that's not on our payment processor. So I'm sharing what she put into, she couldn't pay. She was in Turkey. So this is what went to my bank. That's 2266.68.
All right, how about Lindsay Thompson? Did she make any additional payments?
No,
Nadine Damian, any additional from
No.
her? Rachel Cole, any from her?
no, she
In
was
fact,
the,
she's the one you gave money back to.
yeah.
Okay, and then how about Fleischman?
Oh yeah, good. Lauren Fleischman delayed, and then still missing payments, but what I have received from her since then is 2634.86.
All right, and then how about, I missed one above that, Linnea Shanley. I think that's one we saw some emails from. Is she the one that paused?
Yeah, we haven't received anything from her.
Nothing from her after that? Okay.
Mm-mm.
All right, let me add these numbers up. 1614.3 plus 633.37 plus 1900 plus 1899.9 plus 1899.9 plus 2266.68 plus.
But sorry, can I interrupt?
34.8. I got total amount of money received after January, in addition to what we saw in the spreadsheet, an extra $12,848.95. So of that, 17% commission would be another $21.84.32 for the plaintiff.
Some of it is not 17% commission though.
What would it be at?
If she sold it in October, which was Lauren Fleischman, and Palmas, that is 15%, not 17.
Ms. Cutler, they all say 17%. They all say 17% except the last one, Fleischman.
Palmas, hold on.
They all say 17%.
Okay, that's fine. Stick to that then. So Lauren is 15%.
All right, let's do it right. So that's 15.
Your Honor, in the interest of doing it right, I might say that Ms. Tate terminated me mid-October, and I was stripped of my ability to complete the month. But if you believe that then makes it so I wasn't given the opportunity to meet the threshold in the month, is my point.
Okay.
And I was also not given the opportunity to complete my final sales call.
I don't disagree with that. Unfortunately, remember Texas law
understand.
says she could. I get it. It would have been nicer, but okay. So there's no doubt that you got an additional 2131.62 over and above the 5,093.90 that was included on that spreadsheet. So that makes the total outstanding right now 593.9. Total amount outstanding in commissions to the plaintiff is $7,225.52. In addition to your commissions, you're seeking the class refund and legal fees. And then our counterclaim is for the time and hassle and the interference caused with Ms. Ramos sending that text message or that communication to the parties. All right. And then the legal fees that defendant has incurred. As a result, for that cancellation, you did refund $1,600 back. Yeah, and that was fully taken out of the commission then. Okay. Anything else, Ms. Ramos?
So I'm just trying to understand their claims for Ms. Cutler's time. Under what claim is, like, why would I be responsible potentially for her time when it was time that she offered prior to even knowing about my text message? I don't know if that's an appropriate question. Excuse me, Your Honor.
Do you have any other evidence you want to present, Ms. Ramos?
I just want to point out that that in that Katie Magelson exhibit, Ms. Tate offered that call prior to knowing about my message. This is something that she gave freely. And that there is no evidence that shows any proximate cause of any of her damages related to any of the actions that I've taken, which were all within my legal rights.
Okay. Anything else?
No, Your Honor, thank you.
All right, Mr. Levy, would you like to make a closing statement?
Yes, just really brief. So these recordings were made for Unfuckwithable at their request and for their benefit. The leads were created by the company. And the entire arrangement was for the benefit of
Objection,
the
Your Honor.
company. Excuse me,
Ms. Ramos, it's not time for objection. He's making a closing statement. He's just telling me his version of things.
Ms. Ramos contacted
Also, real quick, Mr. Levy, Ms. Ramos, you get a final chance to redress what his closing
I'm
statement.
sorry. Thank you.
Just be silent.
Thank you.
And write down your complaints. Mr.
Ms.
Levy, go
Ramos
ahead with your
contacted
closing
16
statement.
clients, which caused Ms. Cutler to spend over 14 hours to contact and repair those relationships. And she also caused over $18,000 in attorney's fees. If she just returned the recordings, this would not have happened. And past that, we thank the court for its time today. And thank you, Ms. Ramos, for being here.
All right, and then Ms. Ramos, you have a chance to have another state.
Thank you, Your Honor. So there is no evidence of the company's request to record the calls. On the contrary, I have evidence that I offered my calls for review in one of my exhibits here. And then I also want to point out that I believe in Texas, there is no conversion claims for digital products. It's for physical products, if that helps at all.
I'm sorry?
I believe that under Texas law, conversion is exclusively for physical products, not for digital products. Digital products are regulated by copyright law.
I don't hear that conversion became a part of the case at all. I'm not, anyway, go ahead, Ms. Ramos.
I'm just going off, I'm sorry, I'm going off of their claims, which were in their filed amendment, and they claimed conversion. So that's what I'm talking about. I'm sorry. Thank you, Your Honor.
All right. I really appreciate everyone's time today. The biggest issue facing both sides is that no one bothered to make an actual contract. Literally everyone just sort of casually hobbled it together, and then it fell apart very, very quickly. So things that have been established and are not really in dispute at all. Ms. Ramos was hired as an independent contractor by the defendant. Ms. Ramos first, though, and the defendant, your relationship began several months prior when you enrolled in a course offered by the defendant. Actually, Ms. Levy, Ms. Ramos, Ms. Cutler, I do need to ask a few more questions because we have a very important question of fact. Ms. Ramos, how did you get paid for the commissions?
It was a bank wire.
You got a wire, and who did that wire come from? Did you look and see who that wire?
Tate US LLC, Your Honor.
Okay, so you got paid by the LLC. And Ms. Ramos, I don't see that you have established a claim as an individual claim of action against Ms. Cutler as an individual. All of your claims do seem to stem from your work with the LLC. So one thing that I would immediately say is that any action would be plaintiff take nothing as a result of her claims against Ms. Cutler as an individual, right? So that part would be taken care of. So then we just look at what are your claims against the LLC, and that's really where the bulk of the case is at, or it's where the entire case is at. So nothing as to the individual, but for the LLC, you were hired, you did do work. There's no dispute whatsoever that still outstanding, you are owed $7,225.52 for commissions for work that you procured on behalf of the defendant. The defendant did receive payment on that, and your right to be compensated for that continues forward. And we worked that all out at the 17% rate. And that does give back a refund for the work for at least the one case, Ms. Cole, that she sought a refund. Ms. Cutler did give that money back, and as a result, you don't get a refund. You don't get to be paid on that one. And I got no issues with that. There's a lot of things here that I will say when I hear these cases, or if you look to examples of cases in other courts, if you're looking for these, those are often going to turn differently because the contract may have specified much, much more clearly what parties could and could not do, including things like contacting them or attempting to poach or doing other things or recording or who keeps it. There seemed to be very little instruction from the outset. And again, I think you've both said this might be a part of what you're learning from it. And great, take that always in stride. Sometimes I say this may be the best non-intentional legal course you ever took, but it may very well strengthen both of you in what you're doing. And I applaud you both for being young entrepreneurs out there, right? Kudos to that. All right. So on the plaintiff's additional case, I would award the $72.25 for your commissions. Then we come back to, you asked for 11,000. I'm not seeing any additional proof of that, but there is no dispute at all that $72.25 is outstanding. So that part would be there. You asked for $400 in coaching. I would award the $400 in coaching. There's no dispute that you participated in one of those and didn't get compensated. You want back the full class refund. When we went through it, you participated in some of it, but not all of it. There's a bit of confusion here. So Ms. Cutler took you out of it originally as her independent contractor, but then it's my understanding that she did restore your access as a participant, right, as a customer of her service. And then really in a strangeness of timing for both parties, you got the cease and desist from Mr. Levy, which, you know, Ms. Cutler's business is doing what it probably needs to do on its legal side. It's taking some action. So I can see there being a reason why Ms. Ramos felt uncomfortable or uncertain about could she access the school platform and really utilize it in the same way. And truthfully, Ms. Cutler might have been a little bit like, why are you here? There may have been ongoing concern. So I think it would be reasonable to both sides, maybe not a legal answer, but an equitable, to give back half of the money. So I would award back $21.05 for the class. All right. I think both parties really, some of this is a result of not having clear information going in. And for that reason, I think you both should pay your own legal fees, right? So I'm not going to award fees for anyone. Now for the counterclaim, so Ms. Ramos, I'm not going to award anything on your $1,500 for legal fees. Okay. I think here, again, a lot of this is just part of the cost of doing business. And you're both businesses. Ms. Ramos, you are an independent contractor. As you said, you have your own businesses. Ms. Cutler, you're here as a representative for your business, which is an LLC. So you're both sophisticated in what you're doing. I think, therefore, you're good to cover your own cost. When we go to the counterclaim is about the time that the company had to spend the LLC in sort of defending itself against claims or things that were raised by Ms. Ramos in her text messages. Now, I reviewed carefully the message from Ms. Ramos, and it's pretty tepid. It highlights a drama. It indicates that she had issues or concerns, things that she thought were lacking and ways she could fix it. But she doesn't say it's wrong or bad, more like, you know, I think if you did this kind of weight training, you get a better result than if you do that kind of weight training, which is a reasonable take to have. People do that. I mean, honest to God, lawyers do that, right, Mr. Levy? Go around and see what one lawyer will think. Oh, yeah, I got a good case. No, I don't think so. So I think there is some in that one. Also, she was not prohibited by any contract up front. Though she is asking and offering to do work, she's not actually saying cancel and come to me. She's offering an assistance in addition to what was being given by the company. I think it's pretty specious for me, so I'm going to award nothing on the counterclaim. And as a result, it's going to be judgment for the plaintiff, and the total amount on that, y'all, let me give you a number. So it's $72.25 for the outstanding commissions, $400 for her coaching class, and $21.05 back for the classes she did not get to complete as part of the course. So it would be judgment today, $9,730.52. That would be judgment for the plaintiff. Again, all parties to bear their legal fees, but we would give court costs. So Ms. Ramos, what it cost you to file the case, you get back that. All right. Now, both parties have a right to appeal. It's 21 days for appeal. Mr. Levy, I'll be honest that I can't tell you as the counter plaintiff, if you appeal, I don't know what the appeal bond will be. Typically, it's double the judgment for the defendant. Justice court's a little different. I don't set a bond. It's just determined by statute. If you're interested in appeal, that might be something to contact the county court about. You can call us and we might have to advise you some other way. All right. Any questions, Ms. Ramos? Any questions about the judgment today or the information I've given you related to appeal?
No, Your Honor, I really appreciate all the time and energy you took. It was a really muddled one, and I think you did a very fair job. Thank you.
I appreciate that. Mr. Levy, any questions?
No.
All right. Thank you both very
Ms.
much.
Cutler, do you have any questions?
Yes,
No,
I'm glad
I
you're asking.
understand how you came to your decision making, and it was cool to watch you do that.
All right. I appreciate both of y'all as well. Again, ladies, go forth, be strong entrepreneurs. Look at a contract. All right. Thank you, Mr. Levy. Very well done. Also really prepared. And Ms. Ramos, you as well. I 2 thumbs up to everyone. Some
Thank
of these
you.
get real wild in the weeds. So thank y'all. Have a good afternoon.